Abusia yeni komo o channel so ha AG politics abri. What's ka so seprendia. Me ko make headlines na jemre na yidi bi exum ni dim ya hobraxi mu. Yenam political highways na dembo inra yesim. Unia court eco break na your oral cases be over vacation no mo kono still omo ebetra so no o mahwe akansa asem no MPP Kwabena Boahene National Signal Bureau case no and Hanan Wahab issue no food and fast stock CEO no and also Nasem no so omo ebehwe na omo atena so no sansem we sei na me no ka sei omo lawyer Samuel Atachia Godfred Odame asem no anyo mu de se adenti na court eco breaker chinchin atwan yenkwa yensem de maje penie se umbetena asem no so na achichire krata ede akoma Chief Justice bafboni ebehia se ibonwram na yehwe ne ko ne de eba abra nimdefo atrase na omoboyi nchemu efasa insemu se engage politics avenue.
And then also the Boahene case are part of these cases that are going to be heard. That like the court will sit even though they are on legal vacation. Hearings scheduled for 11, 12, 13 August 2026. That is for the Republic versus Boahene, Angela J. Boateng and Advantage Solutions Limited. That's the company that they set up. Then the firm says it worked throughout. That's the Samuel Atachia's firm says that, well, to the extent that they worked throughout the legal year of October 2025 through to July 2026, they cannot attend to the courts during the legal vacation because they also deserve the vacation. They want to also rest. And so these cases involving their clients, Boahene, Angela J. Boateng and Advantage Solutions, scheduled for that legal vacation period of 11, 12, 13 August 2026, they cannot attend to the courts. And they argue that the directive from the Chief Justice disrupts the lawyers' personal and travel plans, that they had made plans. Atachian says he had made plans for this vacation period to travel and also have some personal time, for himself and obviously his loved ones. But with this decision or directive from the Chief Justice that the courts will sit during this vacation to hear cases involving his client, no, he's not going to have it. It says the legal vacation exists for both lawyers and judges for them to rest. And also is warning that the directive risks exposing the Chief Justice to claims of selective justice. And also in this letter that we have cited, Samuel Atachia notes that other criminal and civil cases have been adjourned to October, November 2026 for after the vacation. So really, why their cases? Now that's the issue that he raises. And he's not alone in this. He goes on, he cites Article 1251, talking about judicial independence, justice administered on behalf of the people, and essentially accusing the Chief Justice of running two parallel justice systems, one that hurries or speeds up special cases, and one that follows the normal course of justice adjudication. He's not the only one in this, and in fact, in this same letter, he uses the phrase, never in an ambulance mode, to describe how ordinary cases are treated. And it's requesting the directive from the Chief Justice for some courts to sit during the legal vacation to be reconsidered, and the warrant withdrawn, and also the matter adjourned to at least the term time, as in after the legal vacation. Well, the other person who shares in this particular concern of Samuel Atachia is Godfred Adame, who also is raising questions about the warrant issued by the Chief Justice to these judges to sit during the legal vacation. His letter was dated 5th August 2026, and he is lead counsel in the case of Republic versus Hanan Abdul Wahab and Hajia Faiza Seidu Wuni. And he is also protesting the warrant authorizing Justice Francis Achibonga to sit during the legal vacation. He is also raised concerns about the judge adjourning the case to 11th and 12th of August 2026 for trial to commence. And this is within the legal vacation period, just as what I just showed you in the case of Samuel Atacha. This is the same judge. Justice Achibonga is the one who is also handling or sitting on this particular case of the Republic versus Kwabena Boahene and Advantage Solutions as well. So the judge told the parties he's a servant mandated by the Chief Justice because the Chief Justice warrant demands that he sits during the legal vacation. Well, Godfrey Dame says the directive is contrary to long-standing rules. High court sittings are for regular term, not vacation. Vacation courts traditionally hear only motions, not trials, without consent of both parties. And he says that there's really no urgency and accuses the arraignment only on 5th May 2026 after earlier charges were withdrawn. And the lead counsel, in this case, Godfrey Damenle, and co-counsel, both, they say they are unavailable during the vacation. One is attending to other matters. One is marking the Ghana School of Law exams as well. So they are occupied. That's what they say within this vacation period. The client and his wife as well, he says they've been denied taking their child who has ADHD abroad for treatment. He calls the directive unprecedented. It warns it may hint at discriminatory treatment and cites Article 17, equality before the law, non-discrimination on political grounds. Article 125, Godfrey Dame as well cites Article 125, same as Samuel Atacha, in this letter protesting the warrant for the courts to be sitting during this legal vacation. They note that an appeal and stay of proceedings already filed pending a Court of Appeal fixed for 19 October 2026 on the question of validity of the charges against his client, and is requesting the Chief Justice to reconsider the directive for Justice Achibonga to sit during the vacation period. Well, these two lawyers speaking the same language, pointing to a matter of, they say, in a discriminatory application of the law. They say it's unprecedented, and it could just put the Chief Justice in the realms of selective justice or the selective application of the law. Martin Pebo is private legal practitioner, is joining us. Counsel, good evening. Thank you for joining. I'm sure you've seen the excerpts of what I just read to you, and you've listened to all the concerns that Samuel Atacha and Godfrey Dame raised in this letter to the Chief Justice about the court sitting during this legal vacation that you officers of the court are on as well. How does this get to you? I mean, is there any real basis for these concerns? Yeah, the lawyers we've been speaking to are torn between both sides. There are those who support this. Others also say that, well, if I'm a lawyer and I have a client, I would want my client's case to be completed as quickly as possible so that, you know, we can know the fate of the client. Where do you stand? Where does the pendulum swing for you?
Yeah, so this become a very complex matter. On the matter of if you're a lawyer, you want your client's case to be tried quickly. Mr. Kansi, it's not that simple. There are a lot of cases that as a lawyer, you don't want the case to be tried quickly. Actually, you are paid to delay it as much as possible so that there can be the next election and hopefully the client's party will come, that they will win elections, and hopefully that case can be discontinued, nulli prosequi, etc., etc. You see, like what the last one that Dr. Boahene did. But of course, we know that some of those cases, I mean, he had to stop them. The unethical behavior of Godfrey Dame in the Jakpa case, Jakpa and Nato forcing case. So the tape is there. You know that the tape has finally made its way to the General Legal Council, and they found a prima facie against him, coaching witnesses, etc. So that's terrible. And some of those cases, if we want to go into each of those, it will delay us. But I'm just showing the example that sometimes lawyers are happy. The Atufosin case didn't delay. He was even acquitted. They were acquitted by the Court of Appeal, just setting the record straight. But Godfred Dami then filed a notice of appeal to the Supreme Court. So that's what Dr. Ayini discontinued. And as I said, rightfully so, because of the unethical behavior of Godfred Dami, right? There are many reasons on the other things, but I'm saying that we can't run away from that perception, and it's real, that sometimes lawyers, we like to delay cases on behalf of clients so that when elections come, it's possible that that client who is politically aligned to a certain party, his party would win. And if they win, chances that the case will come to an end are great. We can't run away from it. That's just what I'm correcting. And that's very, very central. In this whole discussion, that's what the whole thing is about. Delay the case as much as possible, right? So when we go to the next part of their statement, that they want to enjoy the vacation, yes, truth be told, that's usually the practice at the bar. We all often look forward to the vacation, okay? But truth also be told, at the right price, most lawyers will leave the vacation and come to court. So it's not just enjoyment of the vacation. So here to my candid opinion is that, look, at the right price, a lawyer would want to, see, the vacation is effectively about 2.5 months, right? To be candid, I don't think that the judges in charge of this case would want to conduct the cases in such a way that the lawyers cannot get any rest at all. I can tell you that depending on how the lawyers negotiate, they can get at least 3 to 4 weeks, minimum 3 weeks out of the vacation of about it's effectively 10 to 11 weeks until about 10th of October. Though I'm saying about 10th of October practically, but usually the way we calculate it legally is a bit less, but practically we add a few days. That's what I'm saying, about 10th of October. So no lawyer should take me up on it. If I want to do the calculations for it to delay, the main point I'm making is that out of the vacation from 1st August to about that 10th of October, the judges would, sitting on these oral cases, they understand that lawyers must also rest. So each lawyer would be able to get at least 3 weeks, 3 to 4 weeks out of the vacation. All right, that's what I'm saying. I don't think that any judge would say that they should work throughout every day throughout the vacation. That's not what it is.
I see. But that's another issue that they cite in here. In fact, in the case of Samuel Atachia, he says that he together with his that the lawyers in his chambers, they have other personal issues to attend to, and so during this legal vacation, so it's going to be difficult for them to attend to the court. Godfred Yeboah-Dami also says that he, together with the co-counsel, are both unavailable during this vacation period. One will be attending to other matters. One will be marking Ghana School of Law exams and as well. So technically, they are unavailable. I mean, they say they've planned their vacation. And as you know, say you're lawyers, you know that within this period, your vacation is already scheduled, so you go ahead. You cite the 2 instances where they could have done this without necessarily, having to go on this path. But from what you do know, I mean, now that they've written to the Chief Justice, how is it going to play out? I mean, because the warrant is already in force, as far as we do know. The dates for these cases to be heard have already been scheduled, 11, 12 of August, which is just a few days away from now.
I would have expected that before bringing out this issue, the lawyers would have negotiated, sought audience with the judges and even the Chief Justice to negotiate something before bringing this out. Because if we are not careful, we would make comments that later will turn out to be unfounded. So I don't want to go too much into it. I expect that they should approach the judges and the Chief Justice and negotiate something. Yes, that will help. Because you see, the problem we face is that, we like to compare with the advanced countries because we want to get there. So if you look in the US, apart from their Supreme Court, that has the vacation. And even the Supreme Court itself, during the vacation, they do emergency cases. So you hear the emergency docket or the shadow docket. They do emergency cases of stay of execution, injunction, okay, etc. Yes, they do emergency cases. And so the judge can be working or the judge is on vacation. There are many stories. You see a judge in the middle of a forest hiking. They will tell you Justice Douglas hiking in forest, and yet they will tell the lawyers to go and meet the judge in the forest. So you can Google it. You'll find those stories at the U.S. Supreme Court during vacation. Justice Douglas says so he is going on hiking. So if when you have an emergency case, okay, meet him in so and so forest where he's hiking. Then they will hear the case in the forest. Then the next day he gives the decision, etc. There are many stories where over there the judge is on in the US, the judge is on vacation and you meet him there. We too, we've made similar laws. Table number 4, that when it is bail and the court is even on strike, etc., you can go and find the judge. Of course, the Chief Justice who will give the directives. If the judge cannot find a public place, they can even go to his house, etc. So the point I'm making is that in the US, apart from their Supreme Court that has the vacation and there are exceptions, even during the vacation, they sit a bit. The rest of their lower courts, the federal courts, the ones that belong to the government. So I'm talking about the circuit court. So the circuit court is like the equivalent of our court of appeal. And then the district court, which is the equivalent of our high court. They don't go on this kind of vacation. They work throughout. Then in the process, as they work throughout the year, the judges go on vacation at certain staggered, they stagger their vacations. So my point is that we want to go this and develop very fast. And so we copy a lot from the US, UK, etc. And I'm saying that is what they do. Their court of appeal is not on such a summer vacation. Their high courts are not on such a summer vacation. But we copied ours from the UK. And even the UK, where they are on vacation, they've made many exceptions. So it's August that a lot of the courts are off. By September, they begin to sit actively. It's a whole complex thing. So I think that the best thing they should do is to negotiate with the judges quietly. It's not everything we need to talk about publicly on radio, other media. Because if the conversations go too much ahead of the lawyers negotiating with the judges, it spoils it makes the atmosphere toxic. Because like the listing we put in the media, if they had finished negotiating, if they had finished negotiating and let's say they had come to say, look, after the Chief Justice directive, we went to see him, or of course, if he is not available, his deputies, etc., and the judges, and the final decision was that from 1st August to about 10th of October, every week, the cases will go on. There will be no respite at all for us. Then we would come in and say, no, that cannot be. It's too abrupt. Like I said earlier on, at least there should be about 3 weeks break, getting to the end of, from about middle of September, thereabout, etc. Then we would have chipped in. But once they've not negotiated, it makes it difficult. So to be very clear, I'm not condemning the Chief Justice directive. No, on the contrary, it's perhaps the beginning of many more exceptions into the vacation. We want to begin to copy more of America
and the United States to improve on what we have. But then again, it's one to look at as well. And in fact, we'll see what the response of the Chief Justice will be to this letter in the coming days as well, because the dates have been set for these cases to be heard. So we'll be monitoring whether the cases will indeed be heard on the 11th and 12th, and then also the dates as has been communicated for this legal vacation period for these 2 cases involving Hanan and then Kwabena Boahene.
We ain't semaho team so a channel so I'm not so depressed. Say, about India to be a media.